Joining us now to explain is Greg Stohr, who covers the Supreme Court for Bloomberg News. All right, Greg, this decision from Roberts is, well, this order, excuse me, is 64 words.
I counted them. Can confirm that. One sentence.
This is David's notes that I'm reading. 64 words. In layman's terms, what does this do?
Well, I meant to count the words, but I'm glad that you did it for me because I forgot to. I mean, it's really just a holding pattern. As you said, it gives the court more time. We're expecting an order that will say either that the president can keep constructing until the litigation is over, or that he has to stop, at least with the above ground work. And instead, what's probably going to happen is we'll get that order, but not until next week sometime. And for the time being, the status quo prevails, and that means he can keep building and building very quickly.
Greg, talk about the arguments that have been made on both sides here, and it seems like a flurry of paperwork here in recent weeks, but I'll read from a statement filed by the National Trust for Historic Preservation in the United States after they submitted their brief to the court. In a statement, the organization said it reiterated in its filing to the Supreme Court earlier this week that the administration has no unilateral legal authority, constitutional, statutory, or otherwise, to build a ballroom on the site of the now demolished East Wing unless and until Congress expressly approves. Expand on that a little bit, if you would. What is this organization arguing?
So it's essentially arguing that the power over federal property belongs to Congress. And unless Congress delegates that authority to the president, he can't do this sort of thing. He can't build. He can't spend money to construct something. So that's kind of the underlying question. And there are a couple different statutes that are involved. And then there's kind of another question that the president is using, which is to say this group, which is designed to sort of protect the country's architectural and cultural heritage, doesn't have legal standing to sue because they haven't been harmed by this. The Supreme Court in general is pretty restrictive when it comes to somebody saying, we want to sue because we don't like how something looks. And that's what the administration says is going on here.
So if the court were to decide that they don't have standing, are there other potential litigants in the wings waiting to try to refile on this? Or is this probably going to be the end of this, at least for now, if the court does say you can go ahead with it? Yeah.
Yeah, I think it's probably going to be the end of it. And, really, even if the court, mentioned that the stay that they're seeking is just while the litigation goes forward. But the administration has said this ballroom is 65% complete. They have essentially said it's gone so far that it would be impossible to take it down at this point. And certainly if the Supreme Court says you can keep building for another X number of months until this legal fight concludes, it's going to be so far along that it's going to be really, really hard to imagine a court coming along and saying, okay, now you have to take it down.
But Greg, is that almost a way of dodging the issue? Is that them knowing that that will be the case if they grant this stay, it will already be built, and then it will be like, oh, well, it's a fait accompli at this point. What are we going to do?
That is certainly the criticism. That's a criticism the National Trust is making, and other opponents of the ballroom, that the president is just charging straight ahead. In the administration's filing the other day, they said we are building we have 250 workers out there going 20 hours a week, 20 hours a day, 7 days a week. And yes, that is the criticism, that they're making it such that there's nothing the courts can do, even if they conclude that the president is acting illegally.
It is the thing to behold. I mean, it's been a couple of months since I've been down there, but I've seen a few construction sites where they've been moving with more celerity than there in Washington, D.C. At the White House. Before we move on, a couple of things we want to ask you about beyond this, but before we move on, we did get this decision from the U.S. Court of Appeals for the District of Columbia Circuit, that 2-1 decision that's led to this coming before the Supreme Court. As you've thumbed through that, leafed through that decision, what did you learn about the way that court has approached this issue?
Well, first of all, it was, two Democratic appointed judges in the majority, a Republican appointed judge in dissent. So it is another one of these issues that is dividing the judiciary along ideological lines. That standing issue that we were talking about seems to be the biggest sticking point. That's also something that commentators have pointed to. That may be if the administration gets this stay, that may be the reason, less than a court saying that they actually have the authority.
Greg, there's two other issues on the emergency docket. One I think is a little complicated for us, but I do want to ask you about these mail-in voting cases. You've got Alabama v. California and Trump v. California. What are these about, and are we expecting to get some sort of decision stays? Are we going to see action on them soon?
Yeah, so I've been expecting action on that for about 2.5 weeks now, and it's been fully briefed and just kind of waiting. What it's about is that executive order that you may recall from the president that would use the Postal Service to limit the availability of mail-in ballots. Essentially, the Postal Service would come up with a list of eligible citizens and would send ballots only to those people. And that is on hold because of a federal district judge's ruling. We're rapidly getting to the point, and we may well be past the point where it's too late to try to put this system in place, even if the Supreme Court were to say it's okay. The administration told the Supreme Court when it filed that we need to have this system up and running by early to mid-August. We're obviously past that now. And even if the Supreme Court were to grant the administration the stay it's seeking, there's actually still a bunch of other procedural stuff that has to happen before it can kick in, including the Postal Service actually issuing the rule that would be in force here.
Greg, in the minute we have left, I just want to ask you about what we've learned overnight here, Canada and U.S. walking away from trade talks and now in place these tariffs that the administration has put in place based on, yes, the Smoot-Hawley Act of 1930, which scholars of the Great Depression know kicked off that sterling moment in our nation's history. We've been through the challenge to the IEEPA tariffs, seen the decision from the Supreme Court there. What is your assessment just to the legal foundation on which the administration is making this next move?
Well, there will certainly be a challenge to these tariffs, maybe multiple challenges. Big thing to remember with that Supreme Court decision, that was a different statute, and that was a statute that never mentioned the word tariffs. And so the question was, does the president have authority to implement tariffs under this law? And the Supreme Court said no. This is a statute that does talk about tariffs, and the question is whether the president is imposing these tariffs in the right way. So it's a very different legal question, and it's possible the answer won't be a black and white. It may be that some of these tariffs that he's imposed are okay and some of them aren't.
Greg, thank you so much. Greg Stohr, our Supreme Court correspondent. Also, we want to know very quickly, what is the vending machine behind you?
What's behind you? Beautiful artwork, a plant. What's in the vending machine?
So it is titled Supreme Court Justices.
Okay.
Wait, this is incredible.
Pictures of justices as of late 2005, before Justice Alito joined the court, but after Chief Justice Roberts joined the court. And I got it from a friend, and I'm pretty sure it's the only gumball machine like that.